Okay, welcome back, everyone. After two such amazing panels, I now have the enviable task of trying to fit all of the other issues that we need to discuss into the last panel that we've named between protection and control, state interventions and assembly. The state interventions there is to try to draw attention to the fact that the police are not the only bodies that play a role in regulating or managing contemporary assemblies. But I think in our conversations thus far, and probably for the large part of this panel, we will often fall into the parlance of talking about the police as the state, flowing from the previous panel that articulated the right. We start with the fundamental obligation that the state has with respect to the right of peaceful assembly, that of no unwarranted interference, and the negative obligation and the positive obligation of facilitation. And I think the state agents that we're going to be describing here are trying in various ways to fulfill those obligations, but nonetheless, in the words that we use, law enforcement, crowd control, public order, crowd management, the language is suggestive of, unfortunately, the practice that we see. But we're going to be thinking not only about the powers, the perhaps most visible and frequently kind of documented ways in which that happens with the control of people's bodies in the physical moment of an assembly, but also to think about some of the chilling and invasive powers of surveillance around and indeed before and indeed after assemblies have taken place. But also, and we'll start with this to try and set off on a positive note, to think of the positive obligations that the police have with respect to that facilitation element of the right, before concluding with some thoughts about how human rights law can address the various challenges that we've raised thus far. Michael has volunteered to take on that small topic at the end of the panel. But so we've got a marvellous panel also in an indication of the diversity of things we have to talk about. We've also tried to squeeze 4 people onto this panel, but they are all splendidly equipped to lead us through this. We have Charmian Werren, who is a lecturer in criminology at the University of East Anglia, where she focuses on police powers and the right to protest. She's also been working on civil preventative powers and ethnographical approaches towards the study of the police. We have Pete Fussey, who is a professor and the head of department in sociology, social policy and criminology at the University of Southampton, but as I think was alluded to earlier, has been also working with Gina and also her predecessor on questions of the use of new technologies, emerging technologies and surveillance, particularly in the context of assemblies. Stuart Maslen, who is currently running a project on IHL at the Geneva Academy, but is also an expert on human rights law, international criminal law, and disarmament law. A weapons lawyer, I think, was adverted to in the summary of expertise in the room. Was probably thinking of you, Stuart. He also worked with the Special Rapporteur on summary executions and the Special Rapporteur on Freedom of Assembly in producing. He was part of the advisory group of the joint report on the management of assemblies in 2016, and a contributor to the UN Human Rights Guidance on less lethal weapons. And finally, Michael has already been introduced to us, but one of the co-editors of the handbook, a legal advisor at Amnesty International, and Law of Protest on Twitter, which I think tells you, and recently Blue Sky, I discovered, tells you everything you need to know about Michael. So an incredibly authoritative panel, and I'll pass over in the first instance to Charmian.
Okay, fabulous. Thank you for that lovely introduction, and I apologise immediately because you've said that I'm going to start us off on a positive note, and I actually don't know if I am going to do that, so I'm very sorry to start with. This panel is called Between Protection and Control, and that's really where I want to pitch the questions. And I'm going to talk about very much UK, if not just the England and Wales context, really, here in terms of what we mean by positive obligations and the way that police have taken that idea and run with it. So I would be interested from around the room if the kind of tensions I'm going to talk about are coming up in other jurisdictions as well. So please do feed that back in the conversations later. So, positive obligations. Obviously, human rights law internationally has set lots of guidance for states and the agents of the state, the authorities like the police, not to interfere negatively with rights, but it also sets positive obligations. States are asked not merely to avoid these restrictions, but they have to do certain positive steps in order to make sure that people do have free exercise of the rights that they are supposed to hold. This comes through in the general comment, it comes through in European human rights law, and this has included various specific things. So it's included, for example, telling states that they need to have the legal and institutional frameworks in place that allow people to exercise their rights. It can be telling the police that they have to take steps in order to protect people if there's a counter-demonstration that's going to affect whether they have that right. Sometimes it's been held that this means you have to, the police, for example, need to actively close roads and block traffic in order to keep people safe while they're exercising their rights. And occasionally there has been suggestions by courts that this might even involve facilitating people into spaces where they can actually have an effective right to have their say, to express and to assemble, where otherwise they wouldn't have access to somewhere, which means effectively they wouldn't have an effective right at all. That one tends to be slightly more controversial, but I might come back to that later. So, in reality, though, what the courts, particularly the European Court, has said is really quite limited. It says that we need to put these things in, but in terms of concrete examples it gives, really that's about the list of it. And quite often it's talking in a much more big philosophical way about what sorts of things states have to do, rather than necessarily setting out specific things that the agencies of the states need to do. And even there, generally the courts have said, well, what you have to do has to be reasonable. The authorities don't have to go beyond what is reasonable to allow it. So it's suggesting that states have to take these steps, but it's not saying so far. Now, where I really want to focus is on the fact that this raises a lot of tensions in the role of police in states. On the one hand, they're being told that they are the enforcers of the criminal law. On the other hand, they're being told that they are the facilitators. They are the people making sure that there are these positive obligations being fulfilled. And those are two roles that are in complete tension with each other. How do you facilitate someone who is actively breaking the law that you are supposed to be enforcing? And this, I think, causes quite a lot of challenges for the authorities. Now, in certainly England, Wales, Scotland, it does apply to Northern Ireland, but as we've already said, that's a quite difficult case study in some ways. Around 2009, we start to see police guidance that really starts to emphasise the importance of this positive obligations and the idea of facilitation that had existed for years in this case law. We start to see it in the guidance that's being created by police agencies given to police in this country for what they should do in their policing practice. So, for example, around 2009, a big report comes out called Adapting to Protest that puts an awful lot of guidance out there saying policing should be no surprises, policing should have lots of facilitation, you should be facilitating as your presumption. The thing is, what happened with that is a really interesting story, because on the surface that sounds brilliant. It sounds like we're taking a very human rights forward approach. But I think the way that it was explained in those documents often lacked a lot of clarity, and I don't really know why that is. It could be because the way the courts talk about these things, they're talking about states rather than necessarily the specific things the police are supposed to do. It could be that, as some people would argue, the police are ultimately an organisation that that need to be in control. I'll let you come up to your own conclusion. But you can either interpret what happened as over-enthusiasm for the idea of facilitation or co-option of the term facilitation. So during my field work, where I've been observing the police in action, I have seen all sorts of things done in the name of facilitation, which arguably are anything but facilitative. So, for example, I have seen police officers go up to people who are blocking a road to say, let's facilitate you onto the pavement, which is an interesting use of the word, and I think not probably what anyone was aiming for. Perhaps slightly more problematic, I've also seen scenarios where there's been two demonstrations happening at the same time in the same place, where obviously this is a difficult thing to manage, and part of positive obligations is to manage this, but where, in order to manage that, the police on the ground almost took control of the demonstrations. making sure that the roads were clear, but in doing so, almost determining, well, when does this march start? Where does this go? And this is where, despite the fact that this is all supposedly in the name of human rights, we can start to question whether this is actually allowing police an awful lot of control and management. And one of the problems is that facilitation in practice has become dialogue. In order to be facilitated, you need to speak to the police in advance. But in doing so, this obviously allows police to make suggestions, for example. And so we have seen, I've seen an example of taxi drivers protesting in London, for example, who engaged in this dialogue process when, I think this is when Uber were given a licence, they weren't very happy about it. They wanted to block all of the roads. The first time they engaged in this process of talking to the police about it, but then a lot of stuff was put on social media saying, please don't drive into London today, there's going to be roadblocks. The second time they wanted to block the roads, they did not tell the police in advance because they felt that their right had been undermined by doing so. And in fact, we have seen some people call for basically protesters to engage in unfacilitated protest. And some people to say, we need to protect ourselves from facilitation, which is why I ask this question about, where we sit between protection and management and control, because on the one hand, this should be a human rights compliance thing that in reality may have been co-opted and used in other ways. I will say one last thing before I finish, though, which is that even though I am suggesting that maybe facilitation in practice has not lived up to all of the hopes, on the other hand, since this period, we have seen a retraction from the idea of facilitation in UK policing guidance. The original report from the HMIC mentioned facilitation something like 47 times in the document. In 2021, we get a new report out called Getting the Balance Right. It mentions facilitation twice. The first time is on page 72 in a chapter called Police Decisions and Their Effect on the Public. It was not mentioning it in a good way. It was suggesting that facilitation had gone too far. And indeed, I have been running some police training on human rights for the last couple of years for senior officers. And when I mention facilitation, sometimes I get giggling from the officers, almost like if you've said a rude word in front of small children. We don't talk about facilitation anymore, but actually the process of positive obligations in the courts has not changed. So this is where, I'm sorry, you said I was going to start us on a positive note, but I suppose what I am saying is perhaps this is a useful starting point for our conversation on that tension between protection on the one hand and control on the other hand. So, thank you.
Yeah, hi. Okay, hi everyone. I'm not a lawyer, as will be probably apparent when I start speaking. So I'm a sociologist really, but a lot of my work has been looking at how sort of law enforcement practice occurs or how technologies are used in practice. So I've spent a lot more time than is healthy on surveillance operations in vans and things like that. But I'll talk a little bit about that. I'm just going to talk about three things and hopefully end on a reason to be cheerful, but we'll see. I'm going to talk a little bit, I've been asked to talk about the surveillance technology, which is what I work on, and the landscape. I'll talk a bit about that, about its impact, and then some bits about oversight and regulation and so on. So the first thing to say is, there's a lot of audits of surveillance technology on policing and protests. We read a lot of reports, a lot of academic studies which tend to list discrete technologies. And these are really helpful, obviously, for issues of accountability or whatever. But I think there's one of the issues here is that often they strip some important context. That often surveillance technologies now in the sort of AI age, they act in concert together. And what that means, I guess, is not that we just add different layers of surveillance. So the landscape is additive, I guess, but the impact is multiplicative, right? So there's an exponential impact because it's the same people, the same groups and constituencies that are affected. So I think that's an important thing. Obviously, there's the other thing that's changed, I guess, recently is the inescapability of opting out in any particularly meaningful way. We have to engage with each other digitally, makes us more visible, it gives states way more coercive potential, and it's also an unregulated space, as we know. Another couple of quick observations as well. I think today's surveillance is, it disrupts a lot of legal distinctions we used to have, like, for example, covert, overt. So a lot of my work, I've just written a book with a colleague on facial recognition technology. The police call it overt, but it relies on covert processing in order for it to function, for example. So a lot of these former categories aren't satisfactory anymore, something for you lawyers to chew over, I guess. So, and the other thing that's really, I think, important now, or sort of 2 or 3 other points really. One is that when we talk about new technologies now, the purpose is difficult to define. They're designed to be interoperable and to adapt in purpose. They're inherently promiscuous. So the idea of a sort of purpose limitation is very, very difficult to establish. Things that aren't really surveillance technologies like a smartwatch or whatever can become one. Depends on context and so on. So we live in so it's really more, and sort of work with Gina and myself and others have been doing, we talk more about surveillance ecosystems rather than discrete technologies. And that ecosystem isn't just technological, it's also regulatory and legal as well, such as we've seen, laws that allow surveillance to be more effective, like mask bans and so on. The other thing just I'll mention before moving on is also about temporality, that surveillance technology and the surveillance of protests now has a longer time window, from social media patrolling, which Gina mentioned earlier, but retrospective facial recognition, as we saw in the case of Glukin and others, and we see all over the world, that images can be captured now and used by technologies that haven't been invented yet in the future in order to prosecute people. Second thing I want to talk about is just about the impact briefly. Gina just sent me, our report was published 20 minutes ago, wasn't it, on chilling effects of surveillance, which was great. Although it's Gina's report, really, you're the first author. So we can talk about the harms, and we focused quite a lot recently on the chilling effects of surveillance, and we were struck by the way they're often dismissed by states and people using surveillance. So we thought, well, we're going to document this, and we spoke to people in 86 different territories and countries around the world, more than 150 interviews and engagements. And we've got about another 100 interviews as well on top of that with other work. And I just want to pull out a couple of issues around that. First of all, is really that chilling effects are manifest, they're complex, but they are profound in how they impact people. They're not binary. People are not sort of chilled or not chilled. There's actually a spectrum of different reactions that people have. And those are kind of quite pernicious and very, very deeply held. So there are degrees. So one of the interesting things is that chilling effects affect people beyond the targets of surveillance. They are vicarious. They can affect entire communities. They are also durable. In our research in Zimbabwe and Uganda, for instance, we found chilling effects to be multi-generational. So when we're starting to think about trying to understand the utility of harm and proportionality and necessity calculations, we often think about these in terms of things we can measure or talk about, like data protection impact assessment, Article 8 or whatever. But actually we need a much better way of conveying these complex and multifaceted harms over a long period of time. Chilling effects impel people towards desocialisation. They erode trust between individuals. They also invite people, many of the interviewees we had, to reduce their visibility online, which obviously makes it impossible to mobilise and galvanise around particular issues. It also undermines people's ability operationally to operate. It drains people, like organisations' finances, for instance, because they're diverted towards cybersecurity and so on. And most important of all, we see chilling effects have enormous mental health benefits. And I think this is a really good argument to make in advocacy. There is so much epidemiological research on the effects of police surveillance, particularly some good work in New York City. But also people we talk to, it's very akin to the psychological impact, psychosocial impacts are very similar to trauma, which we've kind of also documented as well. And maybe there's a public health argument that's important there. But the third area, the reasons to be cheerful, is what do we do about this? So a couple of us in the room, but also a good friend and colleague of mine, Darren Murray, and myself work quite closely with Clement Voulet on drafting parts of the model protocol that came out in 2023, but also on the kind of guidance around technology that came out around that. And I just wanted to say a couple of things, really, that there are a couple of principles in there that I think, well, I would say this, obviously, that I think are kind of relevant. Protests now have become surveillance opportunities, and that's without any debate, I don't think. And one of the issues here is because of the capability of surveillance, often authorisations give a blanket authorisation. So as we know, protests and assemblies evolve, they're dynamic things involving complex and dynamic human beings, and they evolve over time. So one of the interesting things here is often from the law enforcement perspective, they often want very vague and very open-ended, strategically vague justifications and necessity or whatever sort of calculations beforehand. And there's some quite interesting things in the model protocol and also in the implementation guidance we get into. And actually, I know the PS&I have taken a bit of a kick in today, the Northern Ireland Police. But in our consultations with police around the world, they actually came up with some of the more interesting responses. So, for example, a common law enforcement justification for using surveillance is participant safety or situational awareness, for example. But then if you take a technology like a drone, that can easily then be used to capture images for retrospective facial recognition, prosecution or whatever. So we make some quite clear distinctions between when a policing purpose changed, what has to happen with authorisation. And just 2 quick points to finish on that. The PS&I make quite an interesting distinction with drones where if you're using a drone for situational awareness, you don't need to record anything. You can just monitor it in real time. Because when you record, that necessarily changes the interaction between the state and citizen, between police and public. And so recording can only happen when there's a new authorisation and a new discrete law enforcement purpose. And whether they do that in reality is a matter of oversight and accountability. But it's I thought that was just such an emblematic response and probably something that could be adapted and developed. I think the final thing I'll just say as well is often when we talk about oversight and regulation of these technologies, we often talk about the very first point in which they're used, the authorisation of use. It's the same in data protection. It focuses on the collection, whereas we need to be more inventive in looking at oversight that covers the whole life cycle of use, where people can be properly investigated afterwards through inspection, the intelligence case that they had for using a device, for instance, whether that was upheld and so on. But I'll finish there. Thank you.
Good afternoon. Thanks very much. Before I attack the substance, can I just say what a pleasure it is to have a whole day without a single PowerPoint. What a joy. Thank you. Kudos to the organisers and to the participants. I'm going to talk about 3 things, and I'm going to mention, starting with the dramatic, where things go deliberately awry, and then ending with what I would suggest will become mundane in the sense of everyday, which may inadvertently or deliberately go awry. But there will be a bit of hope in there, I promise you. The first issue is around widespread violent repression of protests that amount to crimes against humanity. For those of you who are not international criminal lawyers, that's a widespread or systematic attack directed against a civilian population, and we heard some examples this morning. I'd mentioned Syria from March of 2011, Venezuela, especially in late 2017, and in 2018, Bangladesh, we heard this morning, July of 24, and then, of course, the Iranian protests. Now, of those 4 examples, and here's a little bit of optimism, in 3 of them, there is either ongoing or there is potential criminal accountability. If we look at Syria, Aleph Najib has gone on trial in Syria. He was one of the senior officials involved in the repression of the protests that began the equivalent of the Arab Spring in Dara province in March of 2011. We can question how far his trial will be fair, but he's certainly got more of a chance than his victims. Here in the UK, we have Salam al-Salam, who has been arrested and charged with crimes against humanity. He was murdering or having murdered protesters in Damascus later in 2011. Venezuela, of course, Venezuela 1 is the case before the International Criminal Court. Maybe there will be some actual trials in the future. We'll wait and see. And then, of course, Bangladesh. the trial in absentia, again, question marks, but nonetheless for the murder of so many in the protests in Bangladesh. So yes, it takes time. Yes, it's a drop in the ocean, but the ability to put people on trial, explicitly allowed for, even if you didn't have the legislation in place at the time under the covenant, the possibility to put people on trial under the basis of universal jurisdiction many years after protesters are murdered, I think it just gives us a tiny measure of accountability. Second, and here it's a mixture of potentially positive and deeply concerning, and that's peaceful assembly in a situation of armed conflict. Because of course, people continue to protest, legitimately so. But here we have a concern that there has been normative erosion, poor interpretation in relation to the notion of direct participation in hostilities. For those of you who are not law of armed conflict IHL lawyers, that's where a civilian protester loses their immunity from attack and can be lawfully targeted and potentially killed under IHL. And 2019, I think, was a seminal year for that issue. We had two issues. We had two scenarios. We had the situation in Gaza along the fence and the protests, and we had 183 people shot to death, 32 of them children. We had 6,106 seriously injured, including 940 children. And the question was, because there were undoubtedly members of Hamas among the group, were the Israelis authorized under IHL to open fire and to kill? And there was a commission of inquiry that looked at this. They start with the words, and the particular problem being the ICRC, with the help of some states, invented the notion of what is called continuous combat function. That means when you're a member of a non-state armed group, you can be targetable at any time. And if you are able to be targetable, then there may be people around you who are not directly participating, and they could potentially lawfully be killed. So the Commission of Inquiry that is set up sets down the words, the Commission doesn't need to opine on continuous combat function. They then go on to do exactly that, to opine on continuous combat function, and luckily they do, because they come out with an extremely important normative statement that the targeting of individuals in a crowd with lethal force purely on the basis of the membership of an armed group is unlawful. That is an exceptionally important statement. Contrast that with the decision, the judgment at trial in the International Criminal Court that year, a couple of months later, in the Entaganda case, where the court, based on the guidance from the ICRC, said that a group of women in a village in eastern DRC who were, wait for it, banging on pots and singing, were directly participating in hostilities and could be lawfully targeted and shot. Something has gone badly wrong with IHL, that is the situation. And then my third issue, where I suggest it's going to become more mundane, I don't think it's going to be a huge surprise to any of you, and that's the use of autonomous force. Now here we have a clear distinction in the jurisprudence, in the doctrine, between lethal and less lethal force. General Comment 37 makes a very powerful, a very clear normative statement. There should never be lethal autonomous force used against peaceful protesters. Absolutely right, and it's good that it's put down there. The less lethal guidance that Thomas and I and others were involved in, obviously talking about less lethal as opposed to lethal force, comes out with a, shall we say, fluffy, and that's a mea culpa, that's not me pointing the finger at anyone else, that it needs to comply with international human rights law. It's kind of a circuitous statement. I think in our next iteration, and it's time now to do the next iteration of the less lethal guidance, we need more an autonomous use of less lethal force including on accountability. Some people say it's too difficult, it's problematic, whether in IHL or in human rights law, to do accountability. I would say that they are wrong. It is entirely possible, but it needs to be provided for. So we've got some work to do. Thank you.
Okay, following your moderately sanguine, I'm not sure where I sit on the continuum of cheeriness, but I want to start with, I suppose I want to make 2 points, or at least raise 2 questions, and I think they draw on a number of themes that have, a number of strands of discussion that have come up already today. The first is the question of whether human rights law has really changed protest policing. Perhaps more importantly, whether human rights law can change protest policing. And of course, there are things we can point to. We can point to basic principles that have taken root, but listening also to Charmian's point about positive obligations and the way in which the language of facilitation is co-opted, I think there are really significant questions about this. And Roger's point too about the dominance of legal categories and legal logics, I think it forces us to ask whether through law we can achieve an improvement in the way that we want to see. And I think it dovetails too with a point, Francesca mentioned it, Marco mentioned it too, in thinking about how we use, not just how we implement existing human rights standards, but how we go beyond what's there. Because I think the vital thing is to think about what are our horizons in international human rights law. Are we prepared just to settle for the standards? And there has been a proliferation of standards in recent years, whether it's General Comment 37 or the Model Protocol. What are the questions that those provoke? Where are the gaps in those? Where do we need to move further? And then, because Ilan raised this question this morning about observers, I want to maybe just touch a little bit on the potentiality of protest observation in this regard too. Can protest observation change protest policing? I mean, to shortcut to my answer, yes, it can. I think how can the questions maybe is how can protest observation do better in changing protest policing? So the first question, can human rights change protest policing? David, I think, mentioned earlier Richard Martin, who again, unfortunately, is not here today, but Richard Martin's work on protest policing talks about the way in which police have a script, a public order script, in which human rights language is very often included. And that goes very much to your point about co-option, I think, as well. When Greg earlier very helpfully went through the different epochs, as they are sometimes referred to in protest policing, mostly in relation to the US, but from escalated force to negotiated management to strategic incapacitation, and what Paul Passavant calls as well security policing. Security policing is kind of preventive in its focus. It looks at how data is gathered and surveilled and used to categorize certain kinds of risk. So there are all those different models of policing. And in some level, I suppose what I want to suggest is that those models remain useful as descriptors, but Ilan's elegant term of the repertoires of policing, I think, is helpful because it does make us think that these are cumulative. Things are not forgotten. And where I suppose I disagree maybe with Paul Passavant, if I'm right in taking this from his work, is that there seems to be, and this is also a fault in human rights law, there seems to be almost a nostalgic attachment to the good old days of negotiated management policing, okay? And I want to push back a little bit against that. What Passavant says very well is that where protest targets the interests of the neoliberal state and the interest that the neoliberal state wishes to defend, then there is a political relation of enmity between protesters and the police, which is inescapable. And that, again, has come up in many of the discussions earlier. Greg said we shouldn't expect established power to be comfortable with protest. Roger was explaining why there's this paramount protection of property. Stephen was talking about how the police have stopped acting with restraint. And I suppose I want to go a bit further. I want to suggest that if our goal within human rights law is ultimately to establish a more comfortable relationship between protesters and the police, that is deeply problematic. And we see that, we see that not just in the examples of dialogue policing that are used in different places. We see it too in how the narratives of safety are used. I was involved, some of you might well have been too, in a report that UNICEF put out a few years ago called Free and Safe to Protest. And it's about children's involvement in protest. And the risk I fear with that language in the title even is that it takes a very paternalistic approach to protest and gives reason for the police to intervene and to style protest using the language of facilitation in a way that's fundamentally inimical to what we want protest to be, the agency that should be at the very centre of protest. Gina mentioned earlier de facto authorisation requirements. Mark was going to laugh because he knew I couldn't get through a presentation without mentioning my pet subject of notification. But I want to mention a recent example from the UK where it was about a Just Stop Oil slow walk in London, where for 70 minutes, or after 70 minutes, the police intervened and the protesters were charged with that new legal euphemism for disruption, interference with key national infrastructure, okay, which that key national infrastructure was the road network. And one of the things that I think is significant in this case is not just about the use of that new Section 7 of the Public Order Act, but it's also about how the court and the Lady Chief Justice in the judgment relates to what David was talking about, good and bad and these binary categorizations. The court used the fact that Just Stop Oil had not notified their protest to remove the statutory defence of reasonable excuse from the protesters under that particular offence. So when international human rights law says that notification requirements should not be enforced as an end in itself, it doesn't really get to the problem here, is that is embedded in this system. It's the system that aims at the pacification of protest, and then these procedural requirements resurface in ways that nobody actually expects them to come up. And I think that case for me was really quite shocking. So as long as we are aiming at protesters being partners with the police in any way, then I think there's a real risk that we're settling for the parameters that human rights law has set rather than being much more ambitious. So the second thing, very quickly, I'm over time, I know. So protest observation, and this, Dominic Bryan is one half of the duo that I hooked up with 30 years ago nearly in Northern Ireland. The other half is Neil Jarman, who's not here either today. But they introduced me to this idea of protest observation, and that was in the context of 1990s sectarian protests in Northern Ireland. And Amnesty's been doing a lot of work in this area too. We have a number of pilot projects involving protest observers. I'm going to refer back to something that Paul Pacify talks about, I think that was a while ago, Sheriff. Paul Pacify asks the question of, why, and he's talking about the US, it's very US-centric, but why, given the presence, the ubiquitous presence of cameras, has that failed to create or enact a change in protest policing? And this is a concern, I think, for when we place our faith in protest observation, something that we need to take much to heart. And he argues that there is a cruelty that is performative in protest policing that is precisely, deliberate. And so it's not an accident that despite the cameras, we see the excesses in protest policing. But what I want to end on, which is the positive thing, in all the things that Charmian, Pete, Stuart have talked about, I think there are opportunities for protest observers to really move the dial forward. So whether it's thinking about in terms of weapons and violence, thinking about how observers can pick up on and frame police abuses as torture and other forms of ill treatment. When it's thinking about facilitation, how can observers really look at things on the ground and decide, making a judgment that this was not actually facilitation, and in turn come up with a positive conception of what that entails. And equally with Pete's examples of surveillance, how can observers begin to document the harms of surveillance so that we begin to articulate them more clearly? Okay, thanks. Sorry.
Thank you very much, all. I think just as a first topic to pick up on a couple of the themes that have come out, both Michael talking as was indeed anticipated about notification, and Charmian talking about the positive obligation and the way that has been co-opted or blurs with choreography in certain circumstances. One element of the normative standards that struck me was the question of sight and sound. And Tim Zick wrote a chapter in the handbook of trying to locate this standard, if indeed there is an international law standard around sight and sound with respect to assemblies. And I just wondered if I could invite perhaps the two of you principally to comment a little on the way in which, whether assembly participants or organisers' decision to notify, you mentioned with respect to the taxi drivers, strategic decision not to notify because it may end up vitiating the purpose of their assembly. But to what extent does the awareness of law enforcement about the purposes of an assembly help inform facilitation that may take place with respect to the sight and sound principle or alternate locations, also thinking about a topic that has also come up today around protected zones where assemblies can't take place apparently, and the implication of those for sight and sound.
You love talking about notification. Do you want to go first?
Yeah, there's a lot in that, and I mean, to start with the notification point, I suppose, and why protesters might decide very sensibly not to notify. I think the point I'm making, because often when I talk about notification, people will say, but it's a fairly innocuous requirement. It's not authorization. The police surely need to know what's going to happen in order that they can facilitate that better. And there's a correlation between notifying and the performance of the positive obligations of the state. What I would argue is, though, that we should hand the agency in a way back to the protesters to decide whether they want that type of facilitation and whether they want the police to... So protesters know very well what they won't get if they don't notify, and they're capable of making that decision. So, I think that is something that should change how we think, because there is this ready acceptance of notification as the baseline, mandatory notification as the baseline in human rights law. On the sight and sound thing, and maybe just to give another example then from the Crime and Policing Act 2026, which has been referred to already, but there are provisions there that now will prevent any protest, a blanket prohibition on any protest outside a public office holder's home. Long list of who qualifies as a public office holder. There's no attempt to, there's already a provision in the 2001 Criminal Justice and Public Order Act that allows targeted measures to be taken against people who might harass someone in their home. But now we have a blanket prohibition with no mention of the countervailing aspects of the right to protest, such as the sight and sound principle, which must also be given due weight. So I do think we're losing sight of the sight and sound principle in some of those provisions. I'll stop at that.
Yeah, I mean, I completely agree. I think there's almost sort of two things that I will speak to, I guess. First being the sight and sound principle of facilitation being put on police is something that actually is really uncomfortable for all people concerned in terms of, you know, why do I have to ask first if I can be where I'd like to be? But secondly, the reason potentially this is being put so much on the police is because there is this closing down, particularly in the UK, but across many jurisdictions, of where you can legitimately be. And this is something when you know ask police and you tell them, you know, well, part of the facilitation duty is therefore to facilitate if people want to be in a certain place. That can often be quite a difficult thing for them to think about, you know, well, how am I, just some random police officer, how am I supposed to decide where someone can be if there are no legitimate spaces for them to be? And increasingly we are seeing across different, you know, whether it is the Section 7, you know, you can't be anywhere near key national infrastructure, which includes a lot of different roads, a lot of different places as well. If you add then civil injunctions, so there are lots of places where you know, companies of various stripes have said, you know, well, we've got a civil injunction to stop people being in this area. If you add then even more localised measures, I'm thinking of public space protection orders that local councils can create to put outside particular places and say you can't behave in certain ways in these areas. Once you do take all of these things into consideration, and then you add in that a lot of people would quite like to have their say outside Parliament, and we have a whole load of very specific bylaws and indeed national, you know, statutory laws about what you can and can't do outside Parliament. You are looking at a closing down set of spaces. So to then say, well, in order to have your effective right, the police will facilitate you to have that, is a really uncomfortable position for all people concerned. So, yeah.
I then wanted to slightly expand from the one form of contentious assemblies of political protests of the sort that both of you have adverted to, and to think about another context, this time where the police already know well in advance that assemblies are going to be taking place, but that can be just as contentious, and that is public order management around football. And I know, Stuart, you have thoughts about UK policing and football, and I'd be interested, Pete, if in thinking about, I mentioned in the introduction, Charmian's looked at football banning orders as a variant of civil preventative orders, but whether in the context of the potential of facial recognition technologies that we yet know anything about how they are being used in the enforcement of such orders around football. But Stuart, perhaps I could kick to you to just say a little around, with the kettling came up earlier with respect to kind of contentious circumstances in which that takes place. But of course, it's a almost routine technique employed in public order management around football in this country. So yeah, invite your thoughts.
I'm going to compliment the police. I realise that might not be the most, but we have learned in the UK. We are not back in the 1970s or the 1980s where management of football crowds was frankly amateurish. Now, I'll be interested to see where you think, Peter, where you think that's gone with your knowledge of surveillance. But I go to football regularly. Sadly, my team almost never wins, but I behave myself when we lose. And I've seen over the generations, because I've been going for 40 years, I've seen how policing has improved. They have understood that the atmosphere that you create, the use of dogs. I love dogs. I don't like dogs being put in my face when they've got muzzles on and they're kind of drool coming out of them. That kind of stuff raises the temperature. And I felt it as somebody who doesn't engage in violence. I felt it in contentious matches. So there has been an improvement overall, I would say, in police management. But I defer to Peter on the how surveillance is being used to perhaps go a bit too far.
Yeah, thanks. Well, I always quip. I've got a season ticket late in Orient, which doesn't account really constitute an assembly because so few people go. But lower league football. I mean, I think there's several issues here. I think you've definitely, and I've regularly gone to football since the 80s and was there in the bad old days. And there is a professionalisation of public order policing, and it is kind of different often as well. It's not like the tactical support group that you would see, in sort of the West End or something like that. So there is a professionalisation within the police of that specific type. I would say, I think there's kind of three things I would add to that. One is, again, you have this massive scope for arbitrary sort of decision made, for discretion around, if you look at things like facial recognition technology, not only where cameras are but also who's subjected to them. So if you look even at something like a football banning order, right? So you have somebody where there is some kind of, I guess, external definition of a reason why that person is wanted. But in my experience, having been on policing operations as well, what we mean by, say, wanted, and what the police mean by wanted are not the same thing. And there is a very general, ambiguous definition, and there's always this additional caveat to include people. So I think that's the kind of first thing. I think something else that's interesting about assemblies like sport are the role of consent there. So if you paid like £100 for a ticket, not in my club, but if you support a good club, for instance, that, it just changes that dynamic of what you're willing to consent to. If you go in an airport, there's different expectations of what you would allow or consent to. It's a bit different in those settings. And then I think thirdly, there's this idea that, there is, I know I'm the white male professor making this point, but there is an issue around the sympathy that's given to some subjects of surveillance. Historically, football supporters have been targets for experimentation, where there's not been a lot of public sympathy on them, which Hillsborough's probably the nadir of that. But I think there is something around sort of large events. So I wrote a book years ago on the London Olympics and sort of the impact of security on East London, but I also worked with colleagues on Paris in 2024. And we do see these kind of ways of which celebratory events, a friend of mine, Jules Boykoff, calls it celebration capitalism, are the way in which, kind of it softens the vocabulary of surveillance. So we have these more celebratory events, which we saw, again, I wasn't in the country at the time, but when there was a coronation, for example, that, you sort of ushered in, you got a massive step change in the amount of facial recognition in London. So I think there's always suspicion around these events where there's less attention and there's less of an adversarial narrative, which softens what surveillance is put in place. Not a direct answer, I know.
But before giving the kind of framing questions, I'll let Stuart, if there were any that you kind of jumped out that you wanted to respond to.
No, I mean, it was just back to an earlier comment that, I had the dubious pleasure of being tear gassed by the Swiss police for the first time a couple of months ago, and they are preparing for the G7 summit, even though it's in France, it's over the side of the lake in Evian. Last time it happened in 2003, a lot of people rampaged through the banking district, and there was a lot of smashing up of stuff. This time they're freaking out long time in advance, and it will be interesting to see if they've learned in the last 23 years how you do this without either shutting down the city or going in with loads of tear gas. We'll see if they've learned. And it's when you... And Thomas, it's the day you're there, so you'll look forward to it. Very sorry, I have to run.
That is probably a cue that I need to relinquish the floor back to our closing remarks, but I give other panellists an opportunity to respond to anything that came out with respect to marshals or attitudes to facilitation.
I'll go first.
I mean, I'm not sure how much I have to add, really. We've had some excellent comments on it, and you're completely right, Val. Of course, the way this is actually seen by many people is that it's gathering intelligence, and it's giving them more and more control and more power, which, I completely take your point that then some people just do not engage in that and do whatever they like regardless. And we see plenty of that happening in cities like London.
That was not my point.
Sorry.
My point is that if they don't do it, they are entitled not to do it. what is the reaction of the police, if proportionate or not. It wasn't a reason to say, but people do what they want, so the police wants to, has that. It was a different approach.
Yeah, I guess the question then, because the way they take the proportionality is dependent on whether they have or not kind of engaged in this process. It goes back to the discussion that you have had in the previous two panels about, good versus bad and who's seen as acceptable or not. And, hopefully this is bringing together various things that I see the links, between the things that we've talked about today. So.
Thanks. Yeah, just take less than a minute, just very quickly. So just to respond to Dominic about sort of how things are now. My relationship with the Met Police, euphemistically, isn't what it was, I can say. So I've no idea. But they do, it is hated by the police as well. It is seen as the most challenging thing in the policing calendar as well, which is kind of interesting as well, for sort of trying to get past this kind of binary sort of way we think about it. Val, very nice to see you again, but also I thought two really important things I thought that resonated with me from what you said. One is this politics of disqualification is really, really interesting, but I was struck by your emphasis on the role of intelligence as well, and it's something I've come across quite a lot in my work as well, and the way it's not only disruptive, but there's this kind of blanket way in which it authorises anything. And intelligence, it's always important to remember, can be something that's evidential, but it can also be something I've just thought up in the bath. It's a real sort of spectrum from a hunch to evidence, and the issue with that is it's inscrutable. And I used to work on surveillance oversight, supporting oversight bodies looking at warrants and things like that, and human rights standards in warrants for communications interception, whatever it is. That's the point where becomes inscrutable, right? So somebody will make a necessity case, but you can never scrutinise the intelligence that underpins it, and that's a real problem, and it's a challenge, globally, I think, and it is really important. And then just to finish, I think one thing that sort of struck me from this panel, but also the day as well. So Greg used a really nice phrase where he talked about the normative framing and sort of that almost like hegemonic way in which things are kind of framed. But there's also, I think, something that Charmian and Michael's, and also I've been thinking about in my own work, is that, there is this kind of strategic intentional ambiguity that's been used in a lot of this stuff. So in this kind of normative framing that gives latitude, whether that's about facilitation, but the idea of what constitutes critical national infrastructure. Communications is critical national infrastructure, for example. So it gives so much scope. And back to Val's point about the use of bail conditions around that is really interesting. And certainly, so that kind of strategic ambiguity, and in my world as well, about what is meant by wanted in an operational versus a judicial sense. So I think there's definitely something, that's clearly a role for regulation and oversight, but that seems to me where the discussion needs to be in a lot of these areas.
I'll try and be quick. I think there are lots of really interesting conversation we could continue having, and I want to pick up on the abolitionist point in the first place. I think that's super interesting because and it also relates, because I'm going to respond to Otto as well, right? Because one of the challenges there, and this is something that when you think of defund the police as a slogan, misinterpreted, I think, in so many ways, because it was about channeling funding into other agencies to do jobs that shouldn't have been police jobs in the first place. Question of, do the police ever have a residual role or some role in protest policing? I think inevitably, yes, they do. But I think it's very difficult when it comes to this question of facilitation and some of the dialogue policing efforts that have been made, because looking at the attempts to create liaison police officers, it's almost impossible, because you have police officers who are serving in this very particular role where they're meant to be friendly, dialoguing with protesters, and yet they're still they're still police charged with enforcing the law. So really difficult questions around that. And in Otto, I wanted to say, I know I was being maybe polemic in the way I was couching things. I'm not anti-police. I don't want to be the second cheerleader for the PSNI on the panel, but I have seen.
Can't take that back.
Improvements in protest policing over the years. I think it's really important for protest observers to document good practices where they see them as well. I'm not against dialogue with the police. What I am against is mandatory dialogue with the police. So, you know, there are nuances in all of that. I want to note that I was passed over for any of the football-related discussion. Some of the room will have views on why that is. But I remember the Kettling case, the Austin case from the UK about the May Day protests, and in that case, the kettling of protesters was justified in part by the House of Lords on the basis that, you know, football crowds expect to be treated in this way, so why wouldn't protesters also? And I remember being indignant at the time, and this is tainted by my view of football supporters, I have to say. I remember being indignant about the comparison being made between protesters and football fans. And I've come very full circle in this, and this is where it, you know, rounds things off back to panel one, this idea of assembly and protest. And we really do have to embrace the, you know, recreational types of assembly that can, with Notting Hill, they can be political, they can be deeply subversive. These kinds of boundaries that we create between things don't hold. So, you know, when it comes to the police and all of these things, the police have an impossible job. I wouldn't want to be a police officer, and they're being told through the cascade of laws that are introduced, through the media, through the courts, iteratively, that their job is to better enforce all these different provisions. So it's an impossible role, but I think human rights law has something to say. I'll stop.
Marvellous. A wonderful note upon which to finish, drawing everything back together.